In today's video, we're going to be talking about death. Fun times, right?
Kind of morbid.
Yeah, a little bit. So honestly, planning for your death is probably not at the top of the list for most of us young 20-somethings. But let's be honest. I mean, look at the state of the world. Death is definitely not a respecter of persons. And so it's really important to at least plan for the end of your life. And so in this video, we're going to be talking about the different ways in which you can plan for, at least from a financial perspective, how you can be prepared for your death and not leave your loved ones scrambling in the event that something happens to you, and also sharing what Mishak and I's current plan is in terms of how we are planning financially for something happened to one of us. So stay tuned.
And fair warning, this might be a little bit of a long one, but it's definitely worth it.
Definitely a very important topic.
So my name is Mishak.
I'm Akiva.
And this is the Bemuse, where we talk about all things personal finance for young adults just like you and, well, us.
Before we jump in, let's define a couple of key terms so that we're all on the same page when it comes to estate planning, which is really what this is all about. The first term is your estate. What is an estate anyway? Your estate is essentially all of the money and properties, so basically all of the assets that you own at the time of your death. The second term is probate. So probate is basically the process where after someone dies, the court in that state that the person was a resident of, they go through their estate, all of their money, all of their assets, and the court determines who gets what, basically. And so that whole process is called probate. And probate can last anywhere from a couple of months to a couple of years.
And especially if you have some unhappy family members, probate, like she mentioned, can go on for years and years and years and years.
It can be pretty messy.
And all those funds can be tied up if you have, like I said, an unhappy family member who is not that pleased with how the funds were allocated out. So you want to make sure that you have all your affairs in order. So if God forbid something were to happen, you were in your right capacities when you made these decisions. So no one has any reason to contest or to object to the decisions that you made.
In the time that probate is going on, I mean, basically all of your assets, they are frozen. They are locked up. Nobody has access to them. If this is something that your family is relying on to bury you, for example, like no one can access that money while the court is going through. Nobody can legally access that money, let me put it that way, while the court is going through the probate process. So really the goal of the estate planning when it comes to your assets, your financial assets, is to avoid probate as much as possible. And there are different ways, different things that you can do so that your assets can be distributed to who they need to be distributed to without going through probate, without going through the court. So that's what we're going to talk about right now.
And I mean, side note, this is something that I actually saw on the news quite a few months ago. There was an individual, I mean, completely different story, like not anything that they didn't plan properly, but I guess they didn't financially. Long story short, the mother passed away. Her son did not have all the funds to bury the mother, and the funeral home, they didn't care. Business is business to everybody. They held on to the body for extended periods of time. They would not allow for a service to be held. So you don't want your money to be held up for any reason, because these people don't care anything about, oh, well, I'll make up a payment plan of this or that. Some companies are not that understanding, and they do not care. They have the legal right, from what I understand, to hold your body if it was a death situation, well, obviously a death situation, and not release it for any reason.
Yeah, and if you're the type of person where you are dependent on someone else's assets or income for you to survive, you definitely don't want those assets locked up where you don't have access to it. So that's another reason why this is super important. So the goal, like I mentioned before, is to avoid probate as much as possible. So here are a couple ways in which you can do that. The first way is to designate beneficiaries on as many things as you possibly can, so they go directly to the beneficiary and it doesn't have to go through the court probate process.
So a few years ago, I actually did this myself. I have many accounts kind of sprinkled all over the place, as well as Akiva. And we pretty much make sure that on all of those accounts that we have a beneficiary listed. Most of those are our parents, just to make sure that if anything were to happen to us, that those funds are divvied out. I don't know about Akiva, but for myself, I've actually literally itemized in a safe that I have in my apartment. I've told my mom where to find the key to access that safe, and all of my account information for every account, the routing and account numbers are listed. And I actually wrote in there per my whatever, kind of like a poor man's will, as you might call it, a DIY will. Just written it out there, if anything were to happen to me, that my funds for these accounts go to my mother, and I signed and dated next to it. Not sure if that's the appropriate way to do it, but at least there's something. So accounts you can list beneficiaries on are retirement accounts, life insurance policies. You can also list them on checking and savings accounts. And the actual term for listing a beneficiary on a checking or savings account is actually called a
payable on death account.
Couldn't remember that, sorry. And what that is basically, simple terms, is that if something would happen to you, that it goes to this person. All the funds in that account on the date of your death go to that person.
Yeah, so that's something that I also take very seriously. If I'm looking to open a significant banking relationship with a bank, I might have a couple of outside bank accounts. I'm trying to do promotional offers and things like that. But where I have most of my banking, where I have the majority of my savings and the majority of my checking accounts, are at banks with which I actually can designate beneficiaries on every single account. So for me, that's an important consideration. If you don't have a lot going on, you're a young 20-something like that, so you just have a few accounts out there, try to look for banks that have the option for you to designate beneficiaries, so that in the event something happens to you, nothing goes through probate, it just goes straight to whoever you have named on that account. And basically, it's a simple process. All you have to do is give them the name, most times their social security number, and that's basically it. So all your loved one has to do in the event that something happens to you is, one, when they contact the bank, they gotta prove to the bank that you actually did die. So most times they'll just send a copy of the death certificate, and then also prove their identity. So of course they should be able to provide their social and verify themselves, and the bank will just get those funds right over to them. So that's one easy way to have your accounts and your assets avoid probate.
Another way is to have a trust, but we don't really think that this really applies to most of us.
99.9% of us here, but it is a way, so we thought we'd throw that out there.
Yeah. And the final option is to have joint tenancy. So this is pretty much when you have an account. Usually most people do it when they're either in a domestic partnership type relationship or when they're married, where they'll have a joint account with someone. So both people's names are listed on the account. So if anything were to happen, that person who's also listed on the account receives those funds
automatically.
Yeah. So they don't really have to do anything. You can pretty much go and clean the whole thing out, and I don't really think that you need to provide a death certificate unless you want to take that other person's name off.
Right.
So there are other assets that you might have aside from bank accounts and a retirement account. A large asset that most people have is a car. So some states allow you to even put a beneficiary on your vehicle. States that allow you to do this are, and excuse me because I'm going to be looking down to give you the complete list, is Arizona, Arkansas, California, Colorado, Connecticut, Delaware, Illinois, Indiana, Kansas, Maryland, Missouri, Nebraska, Nevada, Ohio, Oklahoma, Vermont, and good old Virginia. So that's quite a few states. There are quite a few that are missing, but at least if you live in one of those states that were listed above, you know that you can definitely, I don't know where you need to find this information out or where you need it listed, whether it be at the DMV, but if something were to happen to you, at least you know that that is also covered. Another large asset that most people have are homes. In some states, you have a transfer on death deed that you can leave your home to a beneficiary. So we'll also add that, for example, if I own a home in Ohio and I live in Maryland, I do not have to live in that state in order for me to list someone for the transfer on death deed. And now I'm going to go into the list of locations where you can list a beneficiary on this transfer of death deed. And again, excuse me because I'm going to be looking down below to make sure that I give you the complete list. Those states are Alaska, Arizona, Arkansas, California, Colorado, the District of Columbia, Hawaii, Illinois, Indiana, Kansas, Minnesota, Missouri, Montana, Nebraska, Nevada, New Mexico, North Dakota, Ohio, Oklahoma, Oregon, South Dakota, Texas, Virginia, Washington State, West Virginia, Wisconsin, and Wyoming.
Quite a few states. So some things just can't feasibly be assigned a beneficiary, and some things will definitely just have to go through the court probate process. So to guide the court in distributing your assets, you would write what's known as a will, or the official name, which is the last will and testament. So most people might think that your will is kind of the end-all be-all of where your assets go. It's definitely not. It has to be processed by the court, and the court has to give the A-OK that they're gonna distribute the assets as you've outlined in your will.
But this really isn't an issue for probably people who
lot
are
of
not
people.
uber wealthy.
Yeah.
So, you know, this is really something that, like I mentioned kind of before, for the rich and famous and wealthy, like Miss Aretha Franklin, who when she passed away, that was a big thing on the news because she apparently did not have a will. And of course, like I said, family members start coming out the woodworks. No, she promised me $5 million. No, she told me if something happened to her that I got the house and that I got this. You don't want to leave those things to chance.
Yeah, definitely not. So the best way to write a foolproof legal will that will stand up in court is to hire an attorney and have an attorney do that for you. However, that does come at a pretty penny, and for those of us who are, you know, debt-saddled young 20-somethings, we don't necessarily got the money for that. So here are some alternative ways, that kind of the next best thing if you don't have the money to engage a lawyer to draft your will for you. So the first option is kind of a DIY, do-it-yourself will. So online you can find in different states kind of the requirements for a will to be considered legal in that state. So for example, Massachusetts, where I live, these are the requirements for a will to be considered a legal will. So the person writing the will must be at least 18 years old. It must be in writing. The person writing it must be of a sound mind. I think I'm of a sound mind. You never know. And it must be signed by you. It has to be signed. Like I said, it has to be in writing, has to be signed. Also, a Massachusetts will has to be witnessed by at least 2 witnesses, and none of these witnesses can be beneficiaries of the will. So if I'm leaving something to Meshach cannot be a signed witness to my will.
And that's really just to make sure that someone isn't, you know, forcing someone to do something against their will. It's, you know, if it's being left to me, then someone else should be there present when it's signed, and that makes sense.
And the last thing is that there are no rules as to who you can leave assets to. Some states have rules where you can't leave certain assets to certain people, but in Massachusetts you can leave your assets to pretty much anyone. So those are the rules for Massachusetts. They're pretty similar, I think, across most states, but some states do have their little nuances as to exactly, like, you know, what in writing means, how many witnesses you need to have, those kinds of rules. So I would say to just do your research for your own state and see what makes sense. So that's the first option if you can't afford an attorney. The second option is to find free legal help. So LSC is an independent nonprofit organization that was established by US Congress back in like the 1970s to provide financial support and civil legal aid for low income, you know, US residents. This organization currently provides funding to 134 independent nonprofit legal aid organizations across the country. So there's pretty much one in every state, every US territory, District of Columbia included. So I'm going to drop a link in the description box below to more information on LSC and where you can find free legal help. So for example, in Massachusetts, my local LSC funded legal aid is administered by the Volunteer Lawyers Project of the Boston Bar Association, and they do offer wills and other important estate documents like healthcare proxies and powers of attorney for those who do qualify. Most times it's, you know, low income or elders. So you gotta be poor or old most times to qualify for these things, but that is an option if it applies to you.
Something else that you might consider is speaking to someone in your human resource department at your employer and find out if they have any sort of legal benefits that you can take advantage of. I know, speaking personally from the company that I work for, we have 2 companies that you can actually sign up for to get legal consulting done. And I think with both of them, a benefit is estate planning and last will and testament and that sort of stuff, where for one flat fee, they will actually sit down with you, help you get all that stuff done, and done properly for the state that you currently reside in. So that's also an option.
Yeah, definitely.